Good morning, students. Once again, welcome to the business law. So today's session, I would cover in these topics. As you can see, essentials of valid offer, essentials of valid acceptance, revocation of offer, and capacities of parties. A few students are sometimes very much confused, or they are having the fear factor that how to go for the study of the business law. So before I start with these topics, once again, I would like to mention here that this study is not very tough. And if step by step, if you are having in your mind the concept of the law, you can easily understand and you can develop the understanding of the concept of laws. So as we are studying, or in my previous lecture, I have discussed with you all that we are studying about the Contract Act 1872. So now you are familiar. I think now you all are familiar with the contract. What is the contract? Because as we know that in the business there are different kind of the transactions, and day by day the business complexities are increasing. So in order to save our interest, we need to have the sound knowledge of the law. And as we know that we have to make the promise, we have to make the agreements. So what is the agreement? What is the contract? Now you are familiar. But as I told you that to be a valid contract, as you are entering into a valid contract, so you should contain the essentials in a particular contract. So what are the essentials? I have already discussed in my previous lecture. But today I would like to mention that there are some essentials of the offer. As we know that offer and acceptance, both the term constitute a particular contract. Without offer, without acceptance, there is no sense, there is no meaning of any contract. So in any organization, in the business, if you are entering into contract or you are making some promises, as I told you that the contract is nothing but the agreement with the promises, and consideration should be there. So when it comes to the offer and acceptance, what kind of the offer should be there when we are constituting a particular contract? If there is a lack of essentials of a offer or the particular requirement as per the law or as per the Contract Act, if there is a lack of the essentials of an offer, valid offer, we can say there would be no contract. So to be a valid offer, to be a valid acceptance, to be a valid contract, there are some essentials. So today's session, definitely we are discussing about the essentials of a valid offer and essentials of a valid acceptance. So what is the offer and what is the acceptance? As if the one party is making a promise or is putting the offer to someone, right, is giving the proposal to someone in order to complete a work or to refrain from doing something, that is the offer. And if the consent is given by the another party, that is the acceptance. So once the offer is accepted by second party, the assent is given on that particular proposal, we can say the offer is accepted. And once the offer is accepted, we can say the agreement is there. But in order to make a contract, a particular agreement as you have entered into must comply the rules and regulations, must have the content, some essentials, because if the agreement is not as per the law, there would be no valid contract. So in order to be valid contract or to enter into a valid contract, we need that offer and acceptance. Both the terms should have some essentials. And what is the offer? What is the acceptance? As I told you, that offer is a proposal made by a party to do something or not to do something, and acceptance, if the consent is given on that proposal, that is the acceptance. So once the proposal is accepted, we have entered into an agreement, and agreement which is enforceable by law, that is the contract. So this is the condition to be a valid contract, that every agreement should be enforceable by law. And what is the enforceability of the law? It means the court can interfere in that. There is a particular legal relationship, otherwise there would be no sense of the contract. As I told you that in order to give a rise to a valid contract, there should be the legal relationship between both or more parties. So what is the offer? What is the acceptance? As you can see, the Indian Contract Act 1872 is a fundamental law governing contracts in India, and it outlines the rules and regulations regarding the formation and performance. Because once the contract is formulated, now we have to see that performance will take place. Both the parties have to meet their obligations and enforcement of contracts. An offer, as per the Indian Contract Act, is the initial step in the formation of a contract. The very first thing is the offer, because if there is no offer, right, so acceptance cannot be given. If the acceptance is given without any offer, so there is no sense of the contract. So first is the offer, and once the offer is accepted, acceptance is there, and both the term exit, that time we can say now the agreement we have entered into. And what is the contract? If that agreement in which we have entered into is enforceable by law, is a contract. And definition, section 2 subsection A of the Indian Contract Act defines an offer as when one person signifies to another his willingness. Because there is a desire of a person that I want this particular thing, or I want this work to be done by anyone. So if any person is signifying that this is my desire, this is my offer to you, so that is the offer, right? So willingness is there to do or to abstain from doing anything. It means there is not always to say that you have to do something. Maybe the party or the offerer who is putting the offer to someone is willing not to do something. It means that person is desiring another person to maintain the distance from doing something or abstain from doing something. That is the willingness, that is the offer, and with a view to obtaining the assent of that other to such act or abstinence, he is said to make a proposal. So he is desiring that another one is giving the consent on that particular proposal. So offer and acceptance, now you are familiar with both the terms, right? And now we come to the essential of a valid offer. As I told you that if you want a valid offer without few essentials that are required by the law, by the act, Contract Act, if there is a lack of the essential, we can say that there is no valid offer. And if you are making the contract without essentials of a valid offer, or if anyone is offering to someone, right, without having the essential, without considering the essentials of a valid offer, that time offer would be invalid. No validity is there. So there is no sense of the valid contract. One by one, we have to look for it, that exactly what are the essentials to be for a particular offer to be valid. The first is an offer may be express or implied. It means the particular offer, the offerer may give the proposal in words, maybe written or oral, and maybe in the words the offer is not given to anyone, but by conduct or by action, if particular offer is made, that is also the offer. So for example, suppose any transport corporation, we take the example of the transport corporation. If the transport corporation is suppose running the buses on the different routes, right, that time the corporation is making the offer by conduct. It means they are offering the passengers to avail the services of the buses. So that is the particular offer by conducting the particular service of the buses on a different routes. So that is the implied offer. Express offer, it means very clearly when the offer is given by the proposer or the offerer in the words, or by saying some words, or maybe words maybe in written language, right? So offer may be express or implied. Second, an offer must contemplate to give rise to legal consequences. It is very important, because if the offer is not giving the rise to the legal relationship. As I told you that to be a valid contract, it is the essential that there should be given a rise to the legal relationship, because the code will not entertain the domestic type contract or the contract which are of the nature of the domestic or friendship. For example, if any friend is making a promise to any other friend for a particular movie, or he is making the particular friend to have a dinner with that friend, a lavish dinner party, or that time there is a breach of agreement, so there would be no particular valid offer. So an offer must contemplate to give rise to legal consequences, because the domestic nature type agreements are not contemplating to follow the legal consequences. It means that offer which is given by the offerer should be in such a way that is giving the rise to the legal relationship, so that the court can entertain, right? And third one is that the terms of the offer must be certain and not loose or vague. If you are entering into a contract and you are giving a particular offer, the offer should be very clear. The terms of the offer must be certain. For example, if the offerer is giving the offer for selling a particular oil, right? For take the example of the oil. So what kind of the oil is being sold to another party, or the offer is given to the particular party. So if there is no certain terms and there is no specific terms of the offer, so that time the offer would be invalid. There is no valid offer, right? So the terms of the offer must be certain and not loose or vague. An invitation to offer is not an offer. This is very, very important, because if you are entering into a particular contract and if you are not aware that someone is not giving you the offer, he is just inviting you for giving the offer to that person. Both the terms are having the difference, because the invitation to offer is not an offer. For example, auction. If there is a particular activity of the auction, and in the auction someone is inviting the people to have the offer to buy some property, so that auction is conducted or is carried on for the purpose of selling some property. So that time, if you say that this is the offer, no, the person who is conducting the exercise of the auction is not making the offer to you. That person is only inviting. That person is willing you to have the offer to that person, right? It means the person who is giving you the offer, right? He is not giving you the offer, he is giving you the invitation for the offer. It means that person is desiring that you should give the offer to that person, and that person will have this right to accept your offer or not. So that there is a particular difference between the invitation to offer and offer. So now I think this is very, very important to when it comes to the valid contract, because it is an essential that offer and acceptance. And offer and acceptance must be in a way that are having these essentials. So this one is very, very important. Now I think the students are clear with this term, that invitation to offer and offer, both the term are having the differences. And next is an offer may be specific or general. What is that? Sorry. It means a particular party can offer to a particular person, right? That is the specific offer. Or maybe that party is willing to give the offer to in the general or to the world. So that is the general. And next is an offer must be communicated to the offeree. Because suppose you are desiring to put the offer to someone, and you are keeping everything in your mind that this is the proposal, this is the offer, and I want that someone should accept it, and you are not communicating properly to another party, so there is no sense of the valid offer. So valid offer is there if you are communicating properly your offer, where you want your offer to a party where you are willing to be accepted, right? So another party should have the knowledge of the particular offer. If that party is not having the knowledge of that offer as you are desiring to be accepted, so that time we can say the particular offer is not going to be communicated properly, right? So there would be no valid offer. An offer should not contain a term the non-compliance of which would amount to acceptance. Another important point, if you are putting the offer and you are offering to someone, and that time if you think or you desire that if the acceptance is not given by another party, and in that order the non-compliance, right, non-compliance is a term of which would amount to acceptance, it would be assumed that the acceptance is already given to your offer. No, there is no any kind of the offer if you are having this term that non-compliance of which would amount or would be like a acceptance, right? So acceptance is must and offer should be communicated before having the acceptance. So without acceptance there is no sense of the valid offer, and offer should be communicated. So these are some essentials of the valid offer. Once you are ready that and you have a look into these essentials, so that time you can say that we are having a very good offer or valid offer to someone or the journal if you are going to have an offer. So offer, what kind of the offer should be there? So if the offer is having these essentials, right, so that time we can say offer is valid and we are going to enter into a valid contract, right? And few other points are there for the valid offer, as invitation to offer already I have discussed with you, but few example. Certain communications such as advertisements, catalogs and displays of goods in a shop window are not considered offers but invitation to make an offer. Sometimes I give this example to the student. Suppose you want the admission in a particular institution, and that institution has given the advertisement in the newspaper for taking the admission. And suppose any student who is aspirant of taking the admission in a particular institution, that time if that person or that aspirant of admission is having a very low or is securing a very low percentage, right, in a particular subject, or aggregate percentage is very low. So that time if by seeing that advertisement that is student approach to the institution and institution denied to take the admission of that student in terms of because the percentage is very low, and the student is forcing the institution that you have given the offer. This is a very very important, that the student is making force, right, or is approaching to the court to enforce that I should be given the admission in this institution on behalf of that advertisement, and the advertisement copy you are holding in your hand. But the court will not force or enforce that particular in the favor of that student. The verdict would not be given by the court, because the court will ask you, the very first question is whether there is a valid offer or there is a acceptance. The student will say that yes, I have seen the advertisement, I have gone through advertisement in a particular dated newspaper, and the institution is denying for the admission on the basis that there is a very low percentage of the marks. So you can say that as per the law, there is a particular point, as I told you, that offer is differentiated with the invitation to offer. In this particular case, the institution is not offering for the admission. The institution is inviting the students to make the offer to the institution for the admission, right? So in that case, the particular verdict would not be in the favor of the students. So we have to identify whenever we are entering into a contract whether we are invited for offer, right? Or we are given the offer, right? So we have to differentiate between the offer and invitation to offer. Other example is the display of goods in a shop window. Suppose you are going to a particular market and you see there are few items or few articles displayed in the showcase, and you approach to the particular shop to buy the product, and due to any reason, if the seller is not ready to sell the product to you, so you cannot enforce this particular contract, or on the basis of this that the offer is there is no valid offer, because the displaying of goods in a shop window is not offering the goods. The seller is inviting you, that is like an advertisement. The seller is inviting you to make an offer to buy the products from the seller, right? So now I think it is very easy to identify whether we are having the offer or we are having the invitation to offer, right? And duration of offer, an offer may specify a time limit for acceptance. Yes, if offerer is giving you the offer, there is a particular term that this offer should be accepted in a particular time period. If the acceptance is given beyond that time period, the offer would be assumed as the cancelled offer, you can say, or the revoked, right? Because the time period has gone away, and now if you want to accept the offer, offer must be put again, right? So you can request the offer to have the offer once again so that you can accept that particular offer, right? Termination of offer, it means the offer which was given to you may be terminated by few factors like revocation, rejection, lapse of time, death, or insanity of either party, right? So there is a particular termination of offer. We have to be familiar with these terms. And the next one is the cross offer. Yes, it is again very important point when we are considering about the offer. So to be valid offer, we should know, we should have the sound knowledge of that cross offers are there. What is that? For example, if there are two parties, right? A party is willing to sell a particular quantity of a goods, right, for a price to someone, and another party to whom the offer is made is willing on the same day to buy that quantity of that goods in that price also. So that is the cross offers. So at the same time, simultaneously, if both the parties are having the offer, there would be the cross offer and it would not be the valid offer. So these are a few points we should keep in our mind when we are entering into a contract, that without valid offer, without valid acceptance, there would be no sense of the contract. And for a particular valid offer, there is a need of some essentials as per the law of contract, or the Contract Act 1872 in India. So these are the particular essentials of a valid offer. And mode of communication, as I already expressed, that the offer can be made orally, in writing, or even implied. As another example, as I told you, the example of the implied contract, when the corporation of transport is running the buses or providing the services to the society, right? You can take the another example, the suppose a shoe shiner, right? Shoe shiner starts shining the shoes of anybody, right? And that person assumes, right, is that shoe shiner or that person definitely is willing for some charges or for remuneration, right? So that would be the implied contract, implied offer, because by conduct or by action, if someone is making any offer, so we can assume that is the offer, and definitely there is offer, and but that offer is called the implied offer, and there would be obligation, right, to be met by both the parties. So if someone denies to pay the charges for that particular service, so no doubt if the party who is the aggrieved party would approach to the court, and court will pass the verdict in favor of that party on the ground of this implied offer. So what is the implied offer? It is very must for every student to have the sense of implied offer. That implied offer is apart from the offer that is made orally or in writing, because the implied offer is done or is made by conducting any exercise, by any act, right? And essentials of a valid acceptance. So as I told you that there are two terms, offer and acceptance. Now we can assume that all the students are very much familiar with the essentials of valid offer. Now it comes to the essentials of a valid acceptance. What is that? Right. So acceptance is what? No doubt, when the proposal or the offer is accepted, when the consent is given on the offer, that is called the acceptance. And for a valid acceptance, there are some essentials again. What are those essentials? Unconditional acceptance. The acceptance must be absolute and unconditional, right? It must mirror the terms of the offer exactly. What is the sense of that? No doubt, when the acceptor, right, when the offeree is giving the consent of the proposal, that should be unconditional, means without any condition. Suppose any offerer is giving the offer that I want to sell my property worth rupees 20 lakh, right? But the acceptor or the offeree is giving his consent by saying that, okay, I give my consent for this property uh, for rupees 15 lakh. So there is a particular difference between the terms of the offer and acceptance. So offer should be accepted in the same way, with the same terms as the offerer is desiring. So it must mirror the terms of the offer exactly, right? So without condition, if the acceptance is given, that time we can say the unconditional acceptance is there on the offer, and offer would be valid and acceptance would be valid. Communicated acceptance. Suppose offer is made by offerer to offeree, and offeree is not communicating in a proper way as per the desire of the offerer. So that time there is a lack of the communicated acceptance, and acceptance is does not exist over there. So the acceptance must be communicated to the offerer, right? And silence or inaction generally does not constitute acceptance. If you are silent with your acceptance, or you are keeping in your mind, yes, I have accepted the offer, so there is no sense of the acceptance. It means offer is not accepted over there, and there would be no valid offer, no valid acceptance, and there would be no sense of the contract. So in order to make a particular valid offer, valid acceptance, there should be some essentials as we are talking about, and communicated acceptance is one of them when it comes to the valid acceptance, right? Mode of communication. The acceptance must be communicated in the manner specified or implied in the offer. As per the desire of the offerer, the acceptance should be given. Suppose the offerer is desiring that acceptance should be given by the courier services, or verbally or written, or on a particular place or in a particular time period. So acceptance should be given in the manner as expressed in the offer. So that time we can say what kind of the mode of communication is required over there. So as per the requirement, compliance should be there. The offeree should give the consent as per the willingness of the offerer, or as per the as the manner specified in a offer, right? And immediate acceptance. Unless the offer specified a time frame for acceptance, right? There is no time frame. The acceptance must be made within a reasonable time after receiving the offer. If there is no mention of the time period in which we have to give our consent, right? So that time, in a reasonable time period, acceptance should be given over there. Otherwise, there would be no sense of any valid acceptance, right? Acceptance by the person to whom the offer is made. Again, there is a point that who is liable to give the consent on the given offer. Nobody else, right? Nobody else, the person who has been given the offer to is having the right to accept that offer, right? Or the third party, you can say. But if unless the offer expressly allows for such delegation, there is no matter who is accepting the offer or who is giving the consent on a given offer. So that time you can say that anybody can accept the offer. But if there is no anything mentioned in the expressly in the particular offer that who is having the right to accept the offer, so that person is eligible to give the consent on that offer who has been given the offer to, right? Acceptance of whole offer. What is that? The acceptance must be of the entire offer, right? Partially, if someone is accepting the offer, there would be no sense of giving the acceptance. As the offer is given to anyone, in the same way, the entire or the complete offer with the every terms should be accepted. Otherwise, if you are accepting partially that offer, or you are accepting the part of the particular offer, right, or you are not agreeing with the all the terms and condition of the offer as given to you, so that time it would be assumed that acceptance is given the partially, so that there would be no valid acceptance on that particular offer. Legal capacity, as earlier we have already discussed that the capacity is considered, or we have to contemplate the capacity of the parties when we are entering into a contract. So what's that? Legal capacity. It means the age of the person or who is giving the consent on the offer. So both the offerer and the offeree must have the legal capacity to enter into a contract. This means they must be of the sound mind, legal age, and not under any legal incapacity or duress that would invalidate their consent. For example, if you are making any agreement with the prisoner or with the foreign ambassador, so that time these parties are not, you are not eligible to make the contract with those kind of the parties. So there is no validity of your contract. So we have to keep in mind that legal capacity is a factor. Legal capacity is an essential of the valid offer and acceptance, because if we are having the legal capacity in the term of legal age, or the parties should be of the sound mind, they should not be of the unsound mind, or insanity case should not be there. So again, we have to follow this particular factor, because it would impact your valid contract.